Thanks, Linda, for the introduction. Yes, we are from the same organization, and my name is Jacey. And today I'm going to focus on the legal reform works that we've done in Hong Kong, and what are the challenges and the ways that we look forward to. So I've shared the screen. So under our association, there's a service unit called Lily, which provides all-round support to victim survivors. And also there's education unit called NT480, Anti-Sexual Violence Resource Center, which provides gender equity education to youth and also offer professional trainings to teachers and social workers. So just like Linda just mentioned that 2 years ago, I think 2018 something, we have been very consciously developing supportive service for victim survivors of image-based sexual violence that we normally call IBSV. But apart from the conventional services that we offer to them, like counseling and legal supports, we initiated the takedown assistance service at the beginning of this year. While providing supports to individuals, we are very aware that advocate for structural change really prevails, and in particularly the introduction of specific offenses, and to fight against the culture that grooms IBSV by stressing the bystanders' roles and responsibility in eliminating this kind of violence. Among the cases that involve image-based sexual violence, the most common type in our observation and statistics is non-consensual taking of intimate images, followed by threats to share and non-consensual actual sharing. And most victim survivors actually experience more than one type of IBSV, and this echoes the continuum nature raised by the scholar Claire McLean, where these violent acts actually are very closely related to each other that cannot be separated from one another. And that is why we conceive that a very comprehensive legal reform is necessary for Hong Kong, because if we only address or criminalize some of them while the rest remained untackled, then victims cannot be fully protected by the laws. So since 2018, we have been advocating for introducing specific offenses that target the full spectrum of IBSV via the means of legal research, submitting position papers, doing survey, and also making our statements on press conference. So the legal reform work all begins with the introduction of the new offence voyeurism proposed by Law Reform Commission in Hong Kong. And at that time, we get in touch with the framework of IBSV, and we think that it's actually a very useful framework for us to formulate legal reforms, because this concept or this framework informs us the scope of acts that the laws shall encompass, and also alarms us that only voyeurism or upskirt photography offense could not cover the full range of violent acts. And these two offenses would overlook many related forms of image-based abuse, such as non-consensual sharing and threats to share. So with the unveiling efforts in March this year, the government has introduced the Crimes Amendment Bill 2021 that contained 4 proposed new offences. I will introduce these new offences later. And now, at this stage, the Legislative Council in Hong Kong is still debating the content of the bill, and it's yet to be passed. But hopefully, we wish that these laws will come into effect by the end of this year. So right now, before the new laws, these are the commonly used offences to charge against IBSV. But we note that actually all of their legislative intents and contexts of these 4 existing offenses are actually irrelevant to IBSV, and therefore it gives rise to many limitations, shortcomings, and constraints in the law enforcement. So go back to the bill that I just mentioned. These 4 new offenses are introduced by the bill, which are first one, voyeurism, second, non-consensual recording of intimate parts, thirdly, publication of images originating from commission of the acts under the above 2 new offenses. And last, the fourth one is the publication or threatened publication of intimate images. Well, it's definitely an advancement to get these laws in place, but we are very conscious that there are still many foreseeable challenges. And in the rest of my presentation, I will highlight some of the challenges and how we could tackle them. Well, first of all, what constitutes the act of theft? As I mentioned, there's a new law targeting threaten to distribute or share intimate images. And actually, it is a very important offense in Hong Kong because, as I said, that apart from non-consensual taking of intimate images, threat to share is the second most serious kind of IBSV. Among our handled cases. And I think according to the survey that we published last year, it's also the second most serious, even more than actual sharing. And in our caseloads, many victims have actually chosen to report the case to police with the hope to deter the perpetrators from further harassment. Criminal intimidation, as I just showed in the slide, is often the charge laid against the perpetrators. But there appears a very typical scenario when the victims report the case to police, that the police often told the victims that the threatening acts carried out by the perpetrators were not sufficient to constitute a criminal act. So as reflected by many victim survivors, they were told that to constitute the criminal act, threats must be carried out in an explicit and conditional way. But the reality is, this is not common at all. So I put the quotes here. This is one of the victim survivors who had reported her case to the police, and she got threatened by her ex-boyfriend to disclose her nude photos online. So she told us that when her ex-boyfriend threatened her to disclose her nude photos, the man has sent her a Google link that included the images with a text message. Everything is contained in this Google link. If you don't give me money, I will play with you slowly. But the police said that his text is not really considered to be a threat under the criminal intimidation. Rather, the perpetrator has to say explicitly, like, if you don't give me money, I will upload your image to the internet. And also he has to say it clearly what image it is. The police officer said my ex-boyfriend's text was too vague. So the truth is, this kind of threat was usually exerted by intimate partner, no matter they are current or previous intimate partners. I think Sophie or Mamta is very conscious about that. Intimate partner violence is often closely related to image-based sexual violence, and you know, among this kind of relationship, because the intimate partners usually have very deeper understandings with each other than those between the stranger relations. So even though the perpetrator expressed the threat in a very implicit way, the victim already knows what he really means behind those words, like I'll play with you slowly, or your dirty things would be uncovered soon. So they don't have to say it in a very explicit way so as to let the other know. But we speculate that the police usually don't perceive these kind of threat cases in the context of intimate partner relationship, rather of stranger relations. And given their lack of understanding of intimate partner violence, we're concerned that the new laws will keep failing the victims of threats, that we're afraid that the scenario depicted in this quote would reappear and reappear. So we wonder, like, will a more exhaustive provision that defines threat be helpful to facilitate the law enforcement officers? I mean, like that of Northern Territory in Australia, which states that a threat that it may be made. I mean, they put in their provision the definition of threat, that kind of conduct may be made by whether it's explicit, implicit, conditional, or unconditional. So we are thinking that maybe these kind of exhaustive provision could help to let the law enforcement officers have more broader understanding of threat or of the definition of some of the legal terms. Secondly, I think according to the government paper accompanied the introduction of the bill, because right now, according to the bill, that only voyeurism and recording of intimate parts are sexual offenses, that while the sharing and threat to share are not sexual offenses. So this is another challenge that we might have to face now and in the future. So this is actually an extract from the legislative brief prepared by the government that they explain why they think non-consensual distribution and threat to distribute are not sexual offenses from their perspective. That they stated in the paper that for publication-related offenses, the motives vary and may relate to revenge, as in revenge porn, blackmail, monetary gains, humiliation, or other non-sexually motivated purposes. So, from the government's perspective, the motives or the motivations determine the nature of the offense. But from our perspective, we think that it is not the motives that determine, rather it is the lack of consent and violation of one's autonomy, especially sexual autonomy, by exposing their intimate images to a third party that decide the gravamen of the illegal acts. I mean, it is the non-consensual and the intrusion of one's sexual autonomy that should determine the severity or the illegality of the new offenses. So, and also because the general public normally do not understand that the act of IBSV, because it may be a very new concept that arise these few years, and before this concept come out or before that we relate it to sexual violence, it is such a norm that intimate images were circulating in the cyber world. And the public usually do not realize that these acts actually ignore or violate one's consent and sexual autonomy. So even if IBSV is criminalized, I guess the society needs plenty of time to understand why it is a wrongdoing and the harms that these acts bring to victims. So to criminalize them, it's true that it makes it illegal, but not necessarily convince the public that they are wrongdoing. while we put efforts on the victim supports, in these 2 years, we have collaborated with NGOs which assist and help the ex-offenders of sexual crimes, including upskirting. So one of their workers share with us, many stories and voices of these perpetrators. And this is actually one of the dialogues in which an ex-offender reveals, how he thinks about upskirting. He said to his counselor that I didn't touch the girls, I didn't hurt anybody, I took the pictures for my own entertainment. Then what's wrong with me? The society tells me that upskirting is illegal, but nobody has ever explained to me why people can't do that. So some perpetrators do understand that these acts are illegal, but they don't understand that these acts are actually violating victims' consent. And even if there's no physical touch, actually it has nothing to do with whether there's physical touch or not, but it's the violation of consent that matters. And also they do not understand that the victims actually get hurt, even if they were not touched, they will still get hurt when they know that their intimate parts were captured without their consent. While for some perpetrators, they are very influenced by the culture in cyber world where everybody is posting obscure photos or those taken from secret filming. And many people were discussing this topic in many chat groups and discussion forums. So even if they know it's legally wrong, they are struggling, with much efforts with the social norm. So they questioned, if this kind of act is wrong, then why so many people are doing it? They got caught because they are unfortunate, they are unlucky, not because they are doing anything wrong. And I mean, this kind of thinking actually quite surprised me when I, got to know that even if they served the sentences, even they were, getting the penalties, they are not, conscious that what they are doing are hurting people. So, we think that apart from criminalizing IBSV, there are still many things that we have to do. And firstly, public education. So even though today I share mainly on our legal reforms advocacy, we are actually doing a lot of, public education, especially to youth, because they are the, the common group of victim survivors, and also the large group of perpetrators, because they are the ones who usually use these online chat groups and circulate the intimate images. So public education to deliver the severity and harms of IBSV is very crucial, that could deter people from perpetrating. And second, to equip police with the knowledge of IBSV and let them understand the circumstances of victims, and also to have more sensitivity in handling the cases. Last but not the least, that of course we have to keep monitoring the implementation of the laws and refine the provisions. So these are the things that I want to share today. Thanks.